Federal court blocks Trump's immigration stops in L.A. Key legal ruling explained. In a significant legal development, a federal appeals court has upheld a lower court's temporary injunction that prevents the Trump administration from carrying out indiscriminate immigration stops and arrests in Southern California. This ruling highlights the ongoing tensions surrounding immigration enforcement in the region and raises important questions about civil rights and government authority. On a recent Monday afternoon, a three-judge panel from the Ninth U.S. Circuit Court of Appeals convened to hear arguments regarding a temporary restraining order that was initially issued on July 12 by Judge Maame E. Frimpong. The federal government contended that this order obstructed their ability to enforce immigration laws effectively. The lawsuit, filed by immigrant advocacy organizations, accused President Donald Trump's administration of deliberately targeting individuals with brown skin during its aggressive crackdown on illegal immigration. The plaintiffs included 3 detained immigrants and 2 U.S. citizens, illustrating the far-reaching impact of these enforcement actions. In her ruling, Judge Frimpong pointed to a mountain of evidence indicating that the tactics employed by federal immigration enforcement were in violation of constitutional rights. She emphasized that the government cannot rely solely on factors such as race, ethnicity, language proficiency, or even someone's job or location to establish reasonable suspicion for detaining individuals. The Los Angeles area has become a focal point in the battle against the Trump administration's stringent immigration policies, which have sparked widespread protests and led to the deployment of National Guard troops and Marines for several weeks. Federal agents have been apprehending undocumented immigrants in various public spaces, including Home Depots, car washes, bus stops, and farms, many of whom have lived in the U.S. for decades. One of the plaintiffs, Brian Gavidia, a resident of Los Angeles, was captured on video by a friend during an incident on June 13th, where he was forcibly taken by federal agents while exclaiming, "I was born here in the States, East LA, bro." This incident underscores the fears many have about the potential for U.S. citizens to be wrongfully targeted. American Civil Liberties Union attorney Mohammed Taizar articulated the gravity of the situation, stating that they are fighting against a system that could allow a U.S. citizen to be seized and mistreated simply for working in a Latino neighborhood. In defense of their actions, the federal government argued that they had not been afforded sufficient time to gather and present evidence in response to the lawsuit, which was filed just before the July 4th holiday, with a hearing occurring shortly thereafter. Attorney Jacob Roth expressed concern over the serious implications of claiming that multiple federal agencies have a policy of constitutional violations. Roth also contended that the lower court's order was overly broad and that the immigrant advocates had not provided enough evidence to demonstrate that the government had an official policy of detaining individuals without reasonable suspicion. He pointed out the 4 factors, race, language, location, and occupation, cited in the restraining order, arguing that the court should not prohibit the government from considering these factors entirely. He maintained that it is legally appropriate to use these elements as part of establishing reasonable suspicion. The judges did not shy away from challenging the government's arguments. Judge Jennifer Sung remarked that while no one suggested that these factors could not be considered at all, relying on them alone creates a broad profile that fails to meet the reasonable suspicion standard necessary for stopping individuals. As a Biden appointee, she noted that in a diverse area like Los Angeles, where Latinos comprise nearly half of the population, these factors cannot effectively distinguish between those who are undocumented and those who possess legal status. She further questioned the potential harm in instructing the government not to engage in practices they claim to have already ceased. In response to the court's decision, Los Angeles Mayor Karen Bass hailed it as a victory for the rule of law and for the city of Los Angeles. "I emphasize the need to continue advocating for justice," stating, "Los Angeles will stand together against this administration's efforts to break up families who contribute every single day to the life, the culture, and the economy of our great city." This ruling not only reflects the ongoing legal battles over immigration enforcement, but also raises critical questions about the balance between national security and civil liberties. What are your thoughts on the implications of this ruling? Do you believe that the government should have the authority to use such factors in immigration enforcement? Share your opinions in the comments. Ninth Circuit blocks Trump's ICE roving patrols in Southern California. Constitutional victory. Here's something that will spark heated debate across dinner tables nationwide. Federal immigration agents can no longer sweep through Southern California neighborhoods like a military operation, snatching people off streets without proper legal justification. The Ninth U.S. Circuit Court of Appeals delivered what many are calling a constitutional victory Friday evening, but others view it as dangerous government overreach that ties the hands of law enforcement. The three-judge panel didn't just uphold a lower court's decision. They delivered a scathing rebuke that exposed the fundamental tension between public safety and civil liberties. But here's where it gets controversial. The court essentially told the Trump administration that if they're truly following the law, then a court order preventing illegal stops shouldn't hurt them at all. Think about that logic for a moment. If, as the government claims, they aren't making stops without reasonable suspicion, then how can they argue they're being harmed by a court order that only blocks stops lacking reasonable suspicion? The appeals panel questioned in their decision. This reasoning cuts to the heart of a debate that's dividing America. The ruling preserves a temporary restraining order that prevents masked, heavily armed federal agents from conducting what critics call snatch and grab operations throughout Southern California's streets. For those unfamiliar with constitutional law, this touches on Fourth Amendment protections that require government agents to have reasonable suspicion before detaining someone. And this is the part most people miss. Reasonable suspicion cannot be based solely on someone's race, ethnicity, the language they speak, where they work, or even where they happen to be standing. U.S. District Judge Maame E Frimpong of Los Angeles made this crystal clear in her original ruling, and the appeals court emphatically agreed. The three appellate judges, Marcia S. Berzon, Jennifer Sung, and Ronald M. Gould, noted something particularly troubling. Ordinary people don't need to do anything special other than simply living their daily lives to potentially become targets of these challenge stops. Let that sink in for a moment. Here's what makes this legal victory so remarkable. Fourth Amendment cases like this are notoriously difficult to win in court. Legal experts explain that plaintiffs must prove not only that they were harmed, but that they face a genuine likelihood of being harmed again in the same manner. It's a high legal bar that few successfully clear. During Monday's heated court hearing, the judges pressed government attorneys relentlessly, even extending their response time to get straight answers. The exchange became particularly intense when Judge Berzon confronted the administration's contradictory statements. After the district court issued its injunction, the Secretary of Homeland Security publicly declared, "We are going to continue doing what we're doing, and you're telling us that's not a policy?" Berzon challenged. Deputy Assistant Attorney General Yaakov Roth attempted to deflect, claiming the policy is to follow the Fourth Amendment and require reasonable suspicion. But the court wasn't buying it. Roth also tried to distance the administration from Stephen Miller's controversial 3,000 arrests per day quota that had been publicly announced in May. In a Wednesday memo, Roth backtracked, claiming no such goal existed. But here's where the government's argument completely fell apart. The appeals court ruled that formal policy statements aren't required to prove a pattern exists. Federal agents have conducted numerous stops throughout the Los Angeles area within just a few weeks, sometimes repeatedly targeting the same locations, the court observed, making future similar stops highly probable. The panel didn't hold back in their criticism, accusing the Department of Justice of misreading and mischaracterizing the restraining order they were trying to overturn. They demolished the government's central argument that law enforcement efforts would be chilled by constitutional oversight. The government has completely failed to demonstrate that they will be deterred from legitimate enforcement activities, let alone in a way that constitutes the irreparable injury required for an emergency appeal, the judges wrote. While this case remains in early stages, with preliminary injunction hearings scheduled for September, The immediate impact has been dramatic. The shock and awe campaign of chaotic public arrests that terrorized Southern California beginning June 6th has essentially ground to a halt across 7 counties: Los Angeles, Riverside, San Bernardino, Orange, Ventura, Santa Barbara, and San Luis Obispo. Mohammed Tajjar from the ACLU of Southern California, representing a coalition challenging arrests of 3 immigrants and 2 U.S. citizens caught in these operations, put it bluntly. The underlying Fourth Amendment law isn't complicated. Even conservative judges would be troubled by the government's actions. Los Angeles Mayor Karen Bass, whose city joined several Southern California municipalities in the lawsuit this week, held an impromptu late-night press conference at her official residence. Emerging from the Tudor Revival-style Getty House with unmistakable determination, Bass declared, "This is a monumental day for Los Angeles." Bass, whose personal connection to the Latino community runs deep through her late husband and extended family, characterized the ruling as a constitutional triumph that reinforces the rule of law. "This decision means people can no longer be snatched off our streets by masked agents, as we witnessed for nearly 2 months," she explained, referencing the increasingly aggressive raids conducted by masked federal agents using unmarked vehicles. Speaking directly to the city's immigrant communities, Bass expressed cautious optimism. "My message is that I hope the paralyzing fear will begin to fade, that people will feel safe leaving their homes again, that workers will return to their jobs, and our local economy will start recovering." The Trump administration has consistently signaled its determination to challenge any judicial restrictions on deportation operations through every available legal avenue. While the next appeal destination remains unclear, Bass predicted the administration would likely petition the Supreme Court. But here's the question that's splitting public opinion. Does this ruling represent a crucial protection of constitutional rights, or does it create dangerous obstacles to legitimate immigration enforcement? The answer likely depends on whether you believe the ends justify the means when it comes to immigration policy. What's your take? Do you think constitutional protections should apply equally to everyone on American soil, regardless of immigration status? Or do you believe immigration enforcement requires more aggressive tactics, even if they push constitutional boundaries? The comment section is waiting for your perspective, and don't expect everyone to agree with you.